In this short video, we're going to look at an evaluation essay on strict liability. Evaluation essays appear on exam 3, and you'll be required to answer one essay on criminal, one on contract, and one on tort. So this strict liability essay could be on your criminal section. The question is, strict liability offences are problematic but necessary if the law is to regulate businesses and protect citizens successfully. Discuss the extent to which this statement is accurate. As usual, 25 marks, and you would have 45 minutes to answer it. I've got an image here of health and safety to give you a clue about the gist of this essay. So the essay is saying that strict liability offences are problematic. Might highlight that. That they are problematic but necessary. I'll highlight that as well. So it's asking you, are they problematic, but are they necessary? And what we're going to answer in this essay is that yes, they're problematic because they can seem quite harsh on the defendant. However, they are necessary because they regulate, essentially, issues to do with health and safety, pollution, gambling, things that are in the public interest in terms of safety. So we're going to need to look at what the law is and is it problematic, and also look at why it is necessary. So this suggested answer came from a student. I've typed it up. The AO1 is in black, the AO2 is in red. Okay. So as usual, as you would expect, we start with a definition of strict liability. So strict liability are crimes or offences that don't require any mens rea on the part of the defendant. So they are an exception to the general principles of criminal liability because we usually need an actus reus and a mens rea. Here, we are finding someone guilty for just doing the actus reus. They don't have the mens rea. So straight away we've got an AO2 point because they conflict with the usual principle, which is concerned about fault. And because the defendant might not have intended or even realised sometimes what he's doing, it can seem very harsh. Strict liability offences are regulatory in nature, so it's usually dealing with preparation of food, health and safety, possessing unlawful weapons and drugs, currency offences, driving offences, drink driving, speeding, driving on bald tyres. And they are all fairly minor offences, but they are required to protect the health and safety of the public. So already in this essay, the question is being referred to. So I'm going to start with Gammon and Hong Kong here. So Gammon and Hong Kong gives the situations where an offence might be strict liability. So usually it's going to be regulatory or quasi-criminal in nature as opposed to a true crime. So it's typically things that are fairly minor, as we've seen here. Should be of social concern. The wording of the act should indicate its strict liability, and often the offence will carry a small penalty. Then gone on to sweet and parsley. And the rule in sweet and parsley is that if the statute or the act is unclear about whether the offence is strict liability or not, the court presumes that mens rea is required. So if you remember in that case, the defendant had let out her farmhouse to students, and unbeknownst to her, they were smoking cannabis there. Now, she was charged with being concerned with the management of premises which were being used for the purposes of smoking cannabis resin. Now, that's a very serious, truly criminal crime. And the Act of Parliament that made it an offence didn't make it clear whether mens rea was required or not. But because it was truly criminal, they said, no, mens rea must be required. We're presuming mens rea is required, and therefore our defendant was not guilty because she had no idea this was going on. We can evaluate that and say that the principle in sweet is very important because generally the criminal law is concerned with fault. And for truly criminal cases, it would be unfair, and in fact a breach of human rights, to imprison a person who wasn't blameworthy in any way. A slight counter to that, of course, is the case of Blake. Now, this was the case where the defendant was, he had a pirate radio station and he was broadcasting illegally. Now, that particular offence is truly criminal in nature. And what I mean by that is there's quite a high sentence for doing that. But even though there was a high sentence, he was found guilty of a strict liability offence because there was an issue of public safety involved. So he claimed that he didn't know he was broadcasting, but they said, well, it's strict liability, so it doesn't matter even if you didn't realise. And the justification for being quite harsh there on Blake was that the pirate radio station could have affected the emergency services frequencies. So strict liability was justified as necessary to make sure that we were keeping those frequencies clear and to also, I suppose, deter people from doing similarly in the future. So Blake was a bit of an exception there because that's truly criminal. Most strict liability offences, as we've said, are regulatory in nature. So having a look at some more cases here. So Callow and Tilstone, it was held that selling unfit meat was an offence of strict liability, even though the meat had been certified by a vet. Of course, that sounds very strange to us now. Oh, look, there's a mistake there with the date. So that sounds very strange to us, but at the time when this case came about, that was the only way of checking that a meat was fit for human consumption. So even though the defendant had taken reasonable steps to avoid selling unfit meat, he was still liable. And this is deemed as necessary. So we're sort of going back to the question here. If you remember what the question is, problematic but necessary. Well, the case of Callow and Tilstone is problematic because it seems very harsh on the defendant, but it is necessary if the law is to regulate food and make sure that food is fit for human consumption. Similar case in Harrow. This time the defendants here had a shop, and the one person that they employed sold a lottery ticket to someone underage. Even though the defendants had trained their staff, they put up signs in the shop to try and prevent this from happening. When their member of staff did sell to an underage person, the defendants were liable because it was strict liability. So again, similar to Callow, because even though they've done all that they reasonably could have, they're still guilty of an offence. And I've put there, the harsh decision is justified as necessary, this time to protect society from underage gambling. So it was a food issue in Callow, a gambling issue in the case of Harrow. Could then look at Storkwayne, and there we had a pharmacist who was guilty of a strict liability offence when he had given drugs on a forged prescription. Now that forgery was an excellent forgery and any pharmacist would have believed it. However, he was guilty even though he was not negligent in any way. And that's justified because we're protecting society from drugs. So again, coming back to that question, problematic decision, the pharmacist didn't make any mistake, anyone would have believed it, but necessary to protect from drugs. Then got the comment here that although the cases seem very harsh, often we have a fine, often we have a low fine. So in Alphacell, a company was fined just £20 for polluting a river. So whilst, yes, it is harsh, we are not putting the defendant in prison for life. Often it's a very small penalty. In terms of evaluation here, you can see it's red. These cases show that strict liability is necessary, again referring to the question, which is good practice. Necessary because it raises standards in health and safety and it's regulating activities involving a danger to health, safety or morals. So it was a food issue in Callow, building safety regulations were involved in Gammon, Blake shows safety of the public in terms of the emergency services. Another really important evaluation point on this is that strict liability is important because we don't have to prove a state of mind. If there were excuses, defences or exceptions to certain types of offences, we wouldn't be able to prosecute particular types of crime. For instance, drink driving would be very difficult if mens rea had to be proven because the defendant could just say, oh, I didn't know. Equally, I've used the example in class, I didn't know I was driving on bald tyres. Well, that's irrelevant because I've committed the actus reus. We don't care about my mens rea. It'd be impossible to prosecute me for that. It'd be impossible to prosecute me for possession of drugs if you had to prove that I knew about it. And all of this makes it faster for the court system, which is an advantage as well. Some more evaluation really stressing the point that our defendants are liable even where they're not at fault, even where they've taken all reasonable care. So Callow, Storkwayne being used as examples there. So you could argue as well, some people say strict liability is a deterrent because it encourages high standards, but you could say, well, these guys did all they reasonably could, but they're still liable. So it's not a deterrent in that instance. Professor Hall has talked a bit about strict liability and said that usually the penalty is small, and so therefore some unscrupulous companies can simply regard the law as a nominal tax on a legal enterprise. So what he means there is, if it's such a low penalty, it's not really going to be much of a deterrent to a business because they'll think, oh, well, if we get fined, it's not much, it's worth taking the risk anyway. So that's quite an interesting evaluation point there. Talks a little bit about the Law Commission here, suggesting that Parliament should state specifically if it's an offence of strict liability. And that would avoid the problems seen in Sweet and Parsley, in Blake, where the courts have to question, is mens rea required or not? Have we rebutted the presumption or not? The practice of allowing the courts to decide seems a bit unfair. It's going to lead to inconsistencies. In this conclusion here, referring back to the question again, they conflict with the usual principle, which means that they are problematic, but they are necessary in order to protect the public. In terms of how the law could be improved, which is always a nice way to end your essay, we could have better regulation, clearer instances of when an offence is strict liability. And another interesting point would be, we could allow the defence of due diligence. Now, due diligence is allowed in some areas of contract law, and due diligence means if you can prove that you took all reasonable steps, then you can avoid liability. So that would help defendants like Callow and Harrow, where they took all reasonable steps. Of course, it wouldn't help defendants like Blake, where, of course, no steps were taken at all. Okay, as usual, I've got the marking grid here, AO1, AO2. Remember, you get 15 marks for your AO2, 10 marks maximum for your AO1. So evaluation's so important, and hopefully you can see that quite clearly in that suggested answer.